And joining me on the show this evening, our big newsmaker on the last word, Dr. Abhishek Manu Singhvi, Senior Advocate of the Supreme Court, of course, Arvind Kejriwal's counsel. Dr. Singhvi, thanks very much for being with us. You really have been, at the forefront of this protracted legal battle. Before I get to the details of the bail order, let me ask you right at the outset, how difficult has this case been? Because of course, we have seen in the past couple of years particularly, getting bail in a PMLA case is anyway extremely difficult. And then when Arvind Kejriwal got bail in the ED case, you had the CBI arresting him. So how difficult has this case been? What have been some of the most difficult challenges for you, representing the Chief Minister of the National Capital, the sitting Chief Minister first in history, a sitting Chief Minister being arrested?
Well, I think in a sense you hit the nail on the head. All such cases are difficult because not only are they in special statutes, not this one, but all the earlier ones, but also because they are under cynosure of political intersection of politics and law. And that cynosure of eyes, the streaming media, and the general political overtones have an effect, I think, on the entire atmospherics and the ambience. So they are difficult cases. But this one is bizarrely difficult. And let me tell you why I say that. I don't know of any case, certainly not any I have done, and very few others would have done, where I have got for you 3, not 2, not 1, 3 release orders under a statute which makes it very difficult to release you, puts a special bar, has section 45, etc., etc. I get you those release orders. The CBI has issued an FIR against you in 22. It has interrogated you for 9 hours in 23. And 2 years later, 22 months to be precise, when I have got 2 release orders under PMLA and one comes later on the 12th of July, in between that, at the end of June, CBI comes and arrests you. Now that's why I am the first one to use the phrase insurance arrest in late June 2024 when this happened.
Yes.
Now, the judge today, one of the 2 learned judges, has used the word frustrate possible release. And I think the sentiment is the same. I don't think CBI should leave the path of some decent amount of objectivity when you have got from a much more difficult statute on the same cause of action, on the same predicate offense, on the same offense, bail or release orders. I think it was very unfortunate in this case, and it was clearly to my mind. I keep my law and my politics apart, but clearly to my mind, a political move to take this action against him at that belated stage should never have been done.
Right. In fact, if you go through the order, the essence is certainly something that the Supreme Court has reiterated time and again, that bail is the rule and jail the exception. But there was this sort of difference of opinion on whether the arrest was legal. Now, that, of course, is something, it was a difference of opinion between 2 judges. But in your opinion, as Arvind Kejriwal's lawyer, do you see this trial as a travesty of justice? Because that's an important point. That's something that the Supreme Court said even in Manish Sisodia's bail, that the trial and the investigation has been a travesty of justice. Would you agree with that, and why so?
If you talk of the trial, the same facts and the same context applies to Arvind Kejriwal as does to Sisodia. The court in this order today has not dealt with the details, but the facts are the same. And both judges have unanimously concurred in bail. And one of the reasons both have given is the inordinate potential delay of an ongoing trial, which, by the way, has not yet started. The word trial itself is wrong because trial has not started. You are in most of these cases with hundreds of witnesses, 80,000, 90,000 digital documents, thousands of other non-digital documents. You are at the stage of the accused being given inspection of the documents under the provisions. So, and both judges have observed today, of course, in the Manish Sisodia case, which I did, the courts have observed in great detail the delay. Now, that links to a much larger and a more important issue, which is a great advance in the law in these cases. And I am privileged to have been able to assist. That is that ultimately in PMLA, which is a much worse statute than CBI's action, it's only a statutory provision which denies you, isn't it?
Yes.
The statutory provision denies you, or supposedly partially denies you. But they said when there is delay, there's a higher provision to that, the article of the Constitution, which says delay defeats your rights as a criminal accused. And therefore, we will hold, and that's been held now, Sisodia and other cases.
And ultimately, as the Supreme Court has also pointed out, it undermines the right to liberty. It undermines the right to liberty, and bail is sacrosanct. But Dr. Singhvi, if you look at the order, some of the conditions that have been imposed by the Supreme Court, though there has been no new condition, there are similar conditions to the ED matter. But would you say that this, in a sense, would curtail the Chief Minister from virtually being a Chief Minister, a functional Chief Minister, given the fact that there is limited authority, limited access to the Chief Minister's office?
Well, that's what political opponents like to do. That's what obviously people who cannot remove an elected chief minister would like to say. But people are forgetting one other basic point. As you said, this is nothing but a continuance of an earlier order of 12th of July. There's not a comma full stop change. But what people forget is that Kejriwal has never held any portfolio. So in any case, he does not sign any files, except one category. That only category where he's obliged to sign files are those which will not go from the office of the government to the LG.
Right.
Now that category is specifically permitted by the Supreme Court order. He can sign and should sign those files. So in that sense, governance being affected is an overstated thing. It's a political hype. And now that he's physically free, governance cannot possibly be affected because his ministers are there as far as file signing is concerned. Those files which go through him and must go through him, he's entitled to under the same order. So this is, I think, an overhype because ultimately you must remember that crimes cannot be basis unless proved.
Absolutely.
To be removing you from elected office.
Right.
The elected has to remove you.
That's a fair point, I think. And Dr. Singhvi, the details aside, certainly a huge victory for you and, of course, the Chief Minister. Thanks very much for being with us.